Good morning, Mr. Mark.
Good morning, Mr. Fishman.
I'm so sorry. Mr. Fishman, thanks. I'm sorry.
May it please the Court. My name is Neil Fishman. I'm here for the defendant appellant Leonard Szerlong. Your Honors, Mr. Szerlong's conviction out of Attleboro District Court for assault and battery should be reversed because evidence was admitted under the forfeiture by wrongdoing doctrine that should not have been admitted. If it pleases the Court, I'll very quickly take you through the relevant facts from the hearing.
But I have a question about the forfeiture.
Yeah.
He didn't want his wife to testify.
Your Honor, actually, that goes to a critical point. There's no proof at all in the record that the defendant did not want his wife to testify.
Well, she was there in the courtroom.
She was there in the courtroom.
He could have called her. So I just have a problem with the basic premise of applying the doctrine here, because it isn't the same as where somebody is unavailable either because they've been killed or they're out of town or whatever.
Yes, Your Honor. So he could have called her as a defense witness. He may not have wanted her as a defense witness. That's quite a different thing from her being a prosecution witness.
But he at least he may not have procured her unavailability, and I think there's a real question on this record, as you point out. But he certainly didn't say, "Okay, I waive my marital privilege; she can testify."
No, she doesn't.
It's not his privilege.
I mean, I'm sorry, right. But I mean, he didn't want to do anything to. I have a very hard time with it here because it just doesn't seem like it's the same as in the circumstances for which the doctrine is adopted or has been adopted.
I agree, Your Honor. At the most we can say about defendant's actions here is that he was, and actions is not the right word, he was a passive actor according to the record. He got married. According to the record, the hearing that happened about whether to apply the forfeiture by wrongdoing doctrine. First, we had the motion papers, and attached to the defense counsel's motion papers was an affidavit from his wife. And in her affidavit, she said, "I got married of my own free will, and I chose to exercise my marital privilege of my own free will." She goes further. She says it's at the very end of my brief in the appendix.
But the affidavit isn't testimony at the hearing, is it?
It
isn't evidence.
That's another interesting point, Your Honor, because the defense counsel said, by all means, let her testify, so long as that we agree that her marital privilege is not waived. Let's hear from her. But the Commonwealth wouldn't go along with that.
So you're saying there was not, I mean, there seems to me there are two critical pieces. The defendant, your client, has to have intended to make her unavailable as a witness. That's what Giles said. There's got to be an intent to make someone unavailable. And secondly, that he facilitated making her unavailable. Right? If those two things are established, then...
I think we need to be very clear about our words here. Under Giles, which came down after this trial, right. I wouldn't use the word intent. I would use the word it has to be defendant's purpose and his design to make her unavailable. And Giles, after
and why did the court err in saying that since he had been seeing her for many, many, many years and then suddenly decided that he immediately needed to get married without telling anybody else about the ceremony, that was not sufficient to provide a preponderance, that his intent here was to keep her from being a witness? Why can the circumstances here not be sufficient to provide that?
Well, first of all, I would suggest, Your Honors, that merely those inferences would be way too weak to provide preponderance.
Was it evidence or statements from the two,
the friend and the sister?
The friend and the sister that he, the defendant, had said, "I'm going to marry her so she can't testify against me"?
No, Your Honor, that is not correct. That is not a correct description of the record. And I will take Your Honors through the hearing. I could do that very quickly. The victim said, according to the friend, she said, "I don't want to testify against my husband." And she also told both the friend and the sister that she realized that the only way to get out of testifying was to marry him. And she also said they had a discussion. That is conceded. There was a discussion. So it's conceded. I concede that the defendant knew that that once he married, that
Getting
after he
married
married the
would have
woman,
this
she would
effect.
have a marital privilege. I do not concede, however, that it was his idea. I do not even concede that he knew before his wife knew about that this privilege would obtain.
Wouldn't you say, putting Giles aside, that if you just read the language of Edwards, and putting aside for the minute the fact that there's no findings here, but if you just read the language of Edwards, that concession, which you have to make, I'm not criticizing you
Yeah.
for it, fits within that whole discussion of collusiveness within Edwards? I mean, I think Giles may change the result, but just Edwards by itself, it would seem to me that there's an argument that here is somebody who doesn't want to testify, and he is acting collusively with her to make that happen.
Edwards has a lot of language in it. Now, in point one of my brief, the argument I make is that what was the evidence that was adduced at the motion hearing was not enough to satisfy the Edwards requirement that you prove that he's intentionally procuring the unavailability of the witness, and you have to prove it by preponderance of the evidence.
And so, but we're not the trial judge. We're here on appeal.
Right.
So our standard has to be more formidable than that of the trial judge. So you're saying that as a matter of law, that the evidence here fell below a preponderance, that the judge could not determine, based on the preponderance of the circumstances, that that was his intent?
Well, Your Honor, yes, I do. And as a matter of fact, this conversation is somewhat academic, because we all know that Giles came down. And Giles, the rule in Giles is that it has to be the defendant's purpose in marrying his wife.
But that's the rule in Edwards, too. Edwards requires there to be the intent to procure her unavailability. So why does Giles change Edwards?
Because Edwards, my understanding of Edwards is it speaks of intent as sort of the intent we know in laws that human beings intend the ordinary consequences of their act, the normal and foreseeable consequences of their actions. Giles goes further. Giles is talking about purpose and design. So in Giles, the defendant, I believe, he killed the declarant. Well, obviously, what happens there is we can say that in killing the defendant, a normal and foreseeable consequence of killing the declarant would be that the declarant is now unavailable. That's not enough in Giles. It had to be that his purpose in killing the declarant was to make that person unavailable. So the same must be said here. It has to be proven by at least preponderance of the evidence that the defendant's purpose in marrying his wife was to have her exercise her marital privilege so that he could escape criminal liability.
Mr. Fishman, then are you saying that the judge made a mistake in drawing the inference that by virtue of their marriage that the defendant had the purpose and design to make her unavailable?
Yes, Your Honor.
That's the error.
That is the error. The only evidence we have is that defendant got married, and he knew. We don't know whether he was told by his wife, incidentally, that he was informed, or he found out, or he knew first. I don't know that there existed such a thing as a marital privilege.
And you're
That's what we
telling
know.
us that what the witnesses testified to was that she was the moving party, not him.
No, I'm not going that far, Your Honor, because what I'm suggesting is that the record is neutral. We don't know.
But you have the timing here. I mean, they were together for, 5 years? And then suddenly, 2 weeks after he allegedly seeks to strangle her, and she has marks on her neck, and just before a dangerousness hearing, suddenly they decide to get married, and the judge can't make an inference that his intent was to marry in order to avoid her testifying?
The simple reply to that, Your Honor, is that this is marriage, and that it can arise for all sorts of reasons. But the more complicated reply would be that that is a very weak inference. I mean, to prove by preponderance that the defendant, his purpose in marrying this woman was to have her exercise her marital privilege, just by the timing aspect, I would suggest would be way too weak.
I take it, Mr. Fishman, that one response might be, for whatever reasons, she may not have wanted
to testify against the man with whom she was living. She may have decided that she wanted to marry him because she didn't want to testify against him. She may have asked him, said, you know, let's get married so that I don't have to testify. In other words, it was not his purpose and design. It might have been her purpose and design.
Thank you, Your Honor. I couldn't have said it any better. In
Right,
fact,
but
and
if
there's
you-
proof to support
if
Your
you
Honor's
take that same
contention.
argument, and therefore, instead of marrying, she said, I need money to get a plane ticket to fly to Indonesia where I can't be available, and he paid for that plane ticket, would that not be sufficient, even though it was her idea?
Well, under Edwards, I would suggest it is, because under the second prong of Edwards, it talks about involved in, correct?
Right.
And the question is whether that prong survives, I would say, Giles. Does somebody tell me why we're doing Giles? Maybe
I
that's...
just picked it up from them, but
I don't know what the correct
we just have a very good
pronunciation is.
Superior Court judge who's Giles, so I...
If I could quickly revisit what Your Honor was saying, and then I'll get to Justice Gant's point. First of all, there is proof in the record that it was, again, in her own affidavit, but also in the testimony of the two women who came forward at the hearing about the whether to invoke the forfeiture by wrongdoing doctrine. The sister said that she told her sister that she didn't want to testify against defendant, and that they had a discussion. This was the only way that she would be able not to testify against him. So yes, the record just as likely supports the inference that it was her idea to marry, it was her idea to exert her marital privilege, and defendant is the one act he does is exercises his constitutional right to marry, and that's what he does.
But assume it was her idea. Does that matter? Under Edwards, it doesn't matter. They may collude together as long as he acts. That's sufficient?
Well, Edwards says yes. If you prove lawful collusion, then that would by preponderance of the evidence, that's enough to invoke the forfeiture by wrongdoing doctrine. But Edwards has a lot of language about what that means.
Okay, but I'll go back to my find Indonesia example.
Yeah.
Would that invoke the forfeiture by wrongdoing?
Now,
doctrine?
in your Honor's hypothetical, he buys the plane ticket.
Because she wants to go, but she can't afford it, so he pays the money. He says, "Okay, I will help you out. I will buy you a ticket to Indonesia."
In buying the ticket to Indonesia, I want to be careful about this, but I would say that's active facilitation.
Okay, so that's enough.
I'm not sure, Your Honor, but
Okay, but saying I do when the just as the piece asks you, do you wish to marry her? That's not enough.
he's exercising his constitutional right to marry. Incidentally, we don't know after he marries that she's going to, he may, in his head, he may have it in his head that although we had the discussion, I don't know what she's going to do. I'll marry her for all sorts of reasons, and then what happens afterwards is anyone's guess. So there's two parts of this. There's the marriage and then her exercising her marital privilege, which she says in her affidavit she did by her own free will. She says in her affidavit there were no inducements.
What we say in Edwards, and it seems to me this may be where the present case falls down. As noted above, there must be some causal connection between the defendant's actions and the witness's ultimate unavailability. The method by which the witness becomes unavailable must, at the very least, be a logical outgrowth or foreseeable result of the collusion. Thus, where the defendant has had a meaningful impact on the witness's unavailability, the defendant may have forfeited confrontation and hearsay objections, etc. So, in here, you're saying that there's no evidence that the defendant did anything.
Well, I take it that the other difference was, to go to Justice Gantz's Indonesian example, once he paid for her plane ticket and saw her onto the plane, let's just add that as a fact, so that she was in fact in Indonesia, that is a little different than marrying somebody because you don't know if your wife is going to assert her marital privilege, correct?
That's exactly right, Your Honor. And I would like to remind the Court, we're talking a lot about Edwards, but the Court really needs to be thinking about Giles when it makes its decision, because Giles is what rules.
In the plane trip to Malaysia, does it make a difference that the defendant purchased the ticket as opposed to just giving the woman the money to fly there?
I'm not sure, Your Honor.
So she
I
says,
would say that example, it's a much more active example than the example we have here. In fact, in Edwards, it was much more active undertaking. In Edwards, you had.
So it's active facilitation.
That's correct.
It seems to be a little bit lesser standard than purposeful conduct.
That's right, Your Honor. And let me take this opportunity to remind the court that all of this forfeiture by wrongdoing doctrine is at heart a doctrine of equity. The basic principle is that a person should not take advantage of their own wrong. The defendant did not commit a wrong. According to the record, he married his wife, and then she went on to exercise her marital privilege.
Well, wrong as defined in Edwards, though, is wrong in the sense of doing something to keep a witness away from court. Now, in other words, so marriage could qualify even though it's a constitutional right. It could qualify. I understand your point about you got two questions here, but it's not just the fact that marriage is, you have a constitutional right to marriage doesn't mean it couldn't be a wrong for these purposes.
I would say that's probably correct, Your Honor, but I would like to take this opportunity to remind the court, or to suggest to the court, that perhaps the preponderance of the evidence standard, which this court has adopted in Edwards, this court might want to take the opportunity to revisit that, considering the direction the United States Supreme Court is going in these cases. The United States Supreme Court is highly protective of Confrontation Clause rights, and that's spelled out quite clearly in Giles, which sets this very strict test for establishing forfeiture by wrongdoing. And I would suggest that this court might want to examine again whether to go to yet a higher standard, the kind that the New York Court of Appeals has, which is the clear and convincing evidence standard.
Thank you, Mr. Fishman.
Thank you, Your Honor.
Good morning, Ms. Eisenhower.
Good morning.
So before you start, let me just ask you, what is the evidence that the defendant had the purpose and design here?
I do want to introduce at counsel table, I have the trial prosecutor with me. The evidence is on page 13 and the motion hearing and first transcript. The woman, Tracy Jordan, the friend, is asked, is there, by the defense attorney on cross-examination, was there a preconceived plan that the victim told her about that the defendant was involved in? And she answers yes. So all of her quotations, when she attempts to quote what the victim actually said on the phone, are more ambiguous. But that's the most definitive statement, is on page 13.
Does that tell us that it was his plan?
No, but I don't believe it has to be under Edwards.
What I'm asking is, what if she had the plan?
That's fine under Edwards.
No, but can we just do it under
sure.
Giles?
Sure.
I mean, unless you're telling me that Giles isn't applicable. No, this is on appeal, so it is applicable.
It is applicable. I would say, so Edwards has three prongs. First, the unavailability of the witness. Yeah. Second, the sort of actus reus, if you will. And then third, the intent. Giles really deals with that third intent element. And I'm thinking that what might be more at issue in this case is the second prong, the act evidence. Because well, we are dealing with both prongs. First, we're dealing with whether his intent was sufficient under Giles/Edwards. And I think that, as the court pointed out, they both do require intent. I don't think there's a difference between Edwards and Giles in the third prong. The questions that Giles...
Yes and no. Yeah. Correct?
I'm sorry.
Yes and no, in the sense that Giles tightens... that Giles makes it, I mean, I haven't found the purpose and design, but I found the design language, not the purpose and the language. But essentially what Giles is saying is the fact that you've killed somebody is insufficient to show that it was your purpose not to have the person testify.
Exactly.
Right? Whereas I think as you read Edwards, it's not entirely clear. Edwards uses the term intent, but it's not entirely clear to me that if we'd had the fact scenario that the Supreme Court had under Giles, we wouldn't have said under Edwards that that was okay. In other words, shooting her so she's not available
Then I've been misreading Edwards, because I actually thought that you had meant that in Edwards,
Is
that it required the
Edwards
same
says that
specific
the
intent.
defendant, quote, must act with the intent to procure the witness's unavailability.
So I thought that was a specific intent to avoid testimony, just as it is in Giles.
Don't you think, though, that another difference between the two cases may be that Edwards, it seems to me, focuses really on, you can basically have a joint intent, and it doesn't quite matter whether it's the defendant or the
Correct.
witness, whereas I think Giles is really focusing on the defendant. I mean,
It does focus on the defendant, but I don't think it has any requirement in Giles of whether he was the originator of the intent, as long as he comes to share the intent. I don't think he has to be sort of the...
But coming to share the intent, again, if taking the evidence to be, I want to get married because I don't want to testify against you, defendant. I'm not sure that by marrying her, that comes to share the intent under Giles.
Assuming that the facts in the hearing were that they did have a conversation, and assuming you're hypothetical, that it was her idea, and
he says, I've always wanted to marry you, you've just been refusing up until now.
perhaps, assuming that is a hypothetical, if he knows that that's her plan and he actively facilitates it, I don't see a distinction between that and the Indonesian example. And as for whether...
May I?
Yes.
If he acquiesces in her plan, what is that?
Well, that's actually the federal rule of evidence, uses the word acquiesce. And I would note that they actually mention in Giles the federal rule of evidence and the acquiesce language. Now, that's why I drew this distinction between prongs 2 and 3. They're discussing the third prong in Giles. And I think the acquiesce language, to some extent, it goes to prong 2 as well as to prong 3, because there's an intent element in the acquiesce. But there's also... it also goes to what actions would be sufficient. So we're in an interesting mix of prong 2 and prong 3.
But
and 3.
I asked you the same question I think I put to the defense lawyer. How do you meet the test in Edwards? As noted above, there must be some causal connection between the defendant's actions and the witness's ultimate unavailability. Where's the causal connection here between the defendant's actions?
I absolutely agree that you're right. Once he marries her, she still has a choice. It's her privilege whether or not to assert it. But that is akin to the fact that she could return from Indonesia. The defendant, she could not have asserted a marital privilege without the cooperation of the defendant in marrying
I don't
her.
have any evidence that they married because of his act of trying to make her unavailable.
I disagree, Your Honor. Obviously, this is an interpretation of the facts, and we don't have findings, as you noted, and that's unfortunate. But from the fact that the judge allowed the motion in limine, I think we can infer that he accepted the testimony before him. And the testimony before him was hearsay statements from the victim in which she discussed an agreement between her and the defendant to undertake this marriage, and that
What's the language that says agreement?
Page 13, the defense attorney asked, was there a preconceived plan? That was his word, and the witness said yes. And then when she quoted, she's...
But a preconceived plan to what?
To marry in order to not testify is the implication from the testimony. And then on page 20, the witness goes on to say, it was very brief, but that they decided that they would get married, and because they knew that if they had gotten married, she would not have to testify against them. So plural. And again, in 22, quotes the victim as saying, well, we decided that if we got married, there's I think she said it's called a common law or something. So that you've got this sort of plural discussion. The quotations are only significant in that they use a plural form. But when she got that direct question from defense counsel, preconceived plan, she said yes.
So not to use an overused analogy, but you don't have to prove that the defendant was the principal. He only need be a joint venturer.
Exactly. I think that, in the joint venture context, we often look to shared intent. And here...
In her act of making the final decision whether or not to testify, he participated in the groundwork for that final decision.
His participation was a but-for condition And there was no marital privilege without his cooperation.
Can I ask you a slightly different question? In Edwards, I take it that the testimony that was ultimately admitted was all hearsay. Essentially, you had
At trial or at the hearing?
Trial,
Sorry.
at
Okay.
trial, right? You
Yes.
had the witness's sister and a friend of the witness. You also had a police officer.
Yes.
But that was also hearsay.
It was largely hearsay. The two pieces of evidence that were not hearsay, the police officer testified to seeing injuries to the door frame in conjunction with the breaking and entering charge that was dismissed, and the friend testified to visually seeing the bruises. So those were the two pieces of physical evidence. But additionally, all the evidence of identity was hearsay.
This was not the witness, the spouse's grand jury testimony. It was not testimony under oath. It was just things that that others claimed she said to them.
Yes, 2 telephone calls.
How do you justify?
Which
I'm sorry, I'm getting to my
Sorry,
question.
finish. I'm sorry.
In Edwards, we left that issue to the side because it was grand jury testimony in Edwards. This is hearsay.
Yes.
I mean, this is not, I said the other's grand hearsay as well. This is not under oath. There's no
So you get to the due process question of whether there's sufficient indicia of reliability to make this fair.
Well, I mean, what kind of hearsay are we going to permit? You get over the confrontation clause. Now you get to this next question.
Well, I would note that I noticed in at least one court, I believe it's Colorado, uses the forfeiture by wrongdoing to deal with confrontation and then requires you to lead through an additional hearsay exception separate from forfeiture by wrongdoing. Other courts treat the doctrine as getting you through both hoops at once.
Understood.
And
Which
Edwards,
seems to be what we do. It did with Edwards.
it seems to be from Edwards, but as you noted,
The Supreme Court suggests as well, don't you think?
I think that they do. I think that they leave it to state law. If the state court wants to put an additional hearsay hoop, that's up to the state court.
Even if you say that the two women's testimony comes in, how does the testimony of the police officer who spoke only to the sister come in?
The police officer later spoke to the victim.
But a
He
lot of
did.
his testimony
You know,
comes
I
from what
hadn't
the sister
thought
told
of that. Well, it's unobjected to hearsay, and she testified, so there's no confrontation problem. But I hadn't really thought that through. I'm sorry.
Clear hearsay.
In a hypothetical situation, if you had a woman who proposed to her boyfriend and said, you know, I want to get married, wouldn't your position be that if he agreed to get married, even if she initiated it, he'd be a joint venturer, wouldn't he?
I think in the best of circumstances, people getting married are always joint venturers.
And so there could never be a situation where a defendant could agree to get married where this doctrine couldn't be invoked.
Well, I agree. I would note that if the plan predates the crime, there's an inference to be drawn that the purpose was not to prevent testimony. The other issue is you can't create I was worried about the situation where any marriage occurring prior to a trial would be looked at as this. And the issue is a different way of framing that is saying that does a marriage before trial create a rebuttable or even an irrebuttable presumption of collusion? And the answer is it can't under due process, because Edwards does require that hearing, and it requires the Commonwealth as the proponent of the evidence to meet a burden. And fulfilling that burden with a presumption would not survive due process. So you would require some sort of affirmative testimony that this was collusive. So you couldn't just presume and to the extent that you can infer from timing, that's very, very limited because of that problem.
Ms. Eisenhower, while you're answering my question, your trial counsel is trying desperately to send you a piece of
I'm
paper.
sorry. Thank you.
My question is going to be, I take it that what you would have is to say if there's some indication in the case of a marriage that one of them at any event was doing it purportedly because she didn't want to testify, and 2, the other one knew that that was her reason for wanting to get married, that in the circumstances of this case is sufficient. It's not that it's not just the timing.
Yes, in this case, it isn't just the timing. It's the statement from the 2 individuals that the wife spoke to. They largely corroborate each other. It's another interesting inference that she's very close to this sister. You can infer from the fact that she says, I don't want you to be surprised by this, blindsided, I believe is the word, but you're going to find out this information in court that I'm married. I don't want to hurt our relationship. So she's clearly close to the sister, and yet she hadn't told her about the wedding. So that's an interesting disconnect, to be both close enough to the sister that you don't want to hurt her, but also have not revealed this information, which does suggest that it is not the normal romantic notion of marriage that we might otherwise think, that there is some sort of...
She might have thought that her sister would oppose the marriage, which given...
That's also a possibility. That's also a possibility. I mean, they're competing inferences, but they were...
So why should, or why don't you tell us why the rule of forfeiture by wrongdoing should apply to the rules of hearsay in addition to confrontation?
Because it is an equitable doctrine, as my brother points out, and the point is to not let the defendant, gain from an act of trying to deprive the court, not to let him game the system. And while confrontation is at this particular juncture a more difficult hoop to leap through than the hearsay rules, they both do exist. And so if you applied the forfeiture doctrine only to confrontation and not to hearsay, it would create a regime in which, it would still incentivize loss of witnesses, because the Commonwealth still would not be put in the same position as it would be if they were available to testify. I mean, frankly, even with the forfeiture doctrine, the Commonwealth isn't in the same position. It's simply not the same thing to be able to admit these out-of-court statements. So no prosecutor would ever choose to have hearsay statements through this doctrine rather than a live witness.
So what we're talking about, and your position is there's not a due process violation in admitting this kind of hearsay. This isn't the witness's statements to the police. This isn't the witness's statements under oath. This is the witness's statements made to friends that are inconsistent a little bit with each other.
I think that under the facts of this case, the fact that they're corroborated by physical evidence plus corroborative of each other gives them sufficient indicia of reliability. I would note in addition, the judge didn't find it so, and there is a gap of time, but I think that the first statement to the friend probably could fall into the hearsay excited utterance exception. It is the next morning, but she's clearly still under the influence of the exciting event. She breaks into tears. It is very spontaneous.
So you do argue then, if I hear you right, that the Commonwealth does need to show that there is some indicia of reliability.
For the due process test. If there was no indicia of reliability, I mean, if it were truly, a barroom rumor or something, then no, that would not be sufficient. But it doesn't have to rise to the level of a formal hearsay exception. It's more akin, I'd analogize to something like the standard for probation revocation.
Reliable hearsay.
Thank you, reliable hearsay.
Thank you, Ms. Eisenhower.
Thank you.
All right.